What's up, guys? This is Child Support School. Classes in session. Today I'm going to make a quick video about how to avoid child support. So there's a lot of comments on my channel and a lot of search traffic around that term. And the answer, I think, is going to maybe surprise some people. But before I get started, nothing in this video is meant to constitute legal advice. Nothing here is an invitation to establish an attorney-client relationship. It's for informational purposes only. Always consult your own attorney in your jurisdiction about your specific set of facts. Okay, so a lot of people want to know how to avoid child support. So I'm going to just cut straight to the chase. If you have a child and it's your child, there's not really any ways to specifically make sure that you can never, you can be guaranteed of never having a risk of having a child support obligation. Okay, so if you have a child and you're not living with the other parent, and you're not the custodial parent, okay, then you've got a significant risk of ending up owing some child support through some kind of court order. And there's multiple kinds of court orders. So it becomes a matter of strategy, okay, like planning. You got, just like anything in life, you got to have a plan. So whether you're talking about your career, your business plan, you want to get a six-pack, you have abs, you got to have a plan for that. You have to have a plan if you don't want to get nailed for child support, okay? And this is not shady. This is not me trying to tell people how to, get over on the other parent and ruin people's lives. I mean, this is legit strategy that we're talking about here. I mean, this is people being responsible to protect their financial life, right? The financial aspect of their life. And so, I mean, first and foremost, if you are not the custodial parent and you don't have any sort of court-ordered time sharing with your kid, right? Then that's the first step. And I've got other videos here where I really go into that deep, but the long and the short of it is most places you go, child support is going to be calculated based on how many overnights, like how many nights out of each year your kid spends the night with you at your house. Okay, so that's really important. You can, if you don't have your parental rights established, every jurisdiction has got some mechanism for you to be able to easily initiate a court case to establish your parental rights, to establish court order time sharing with your kids, and to set up child support that way, the right way, conduct adequate discovery and everything. But it's inside of a case where you're establishing your parental rights, you're establishing some custody. Now, a lot of parents want to say, hey, look, I need to go for 50-50. I want 50-50. I personally believe that 50-50 is generally best for kids. I think kids should have equal time with both parents, unless one parent is a true danger to the child, which I think those allegations go around all the time. But I think the actual situations where that's the case, where one parent is truly dangerous, I think that's actually really rare. And most of my judges in my jurisdiction, I think, would agree with me on that. But so you go for 50-50 custody. There's still going to be some child support. In a 50-50 scenario, whoever makes more money is going to probably owe a little bit of child support to the other parent, but it's not going to be anything like what it would be if it was calculated with you having no court-ordered overnight time sharing with the kids. So that is the first way to really protect yourself and possibly avoid that child support obligation. All right. Next is if you have any doubt that this child could be yours, I mean, that's a really big one. So the state is often going to go after people for child support and just assume that it's your kid if the other parent tells them that it's your kid. All right, so I deal with the state in my state. I deal with the state Department of Revenue a lot with these child support matters, And there's two ways that the state can get involved in child support. That's one, if the other parent has applied for Medicaid or food stamps or cash assistance. The state wants to recoup the money that they spent on that. So they will go after the other parent for child support. And as they're processing those child support payments in, they will kind of skim a certain percentage off those payments and recoup some of their money. The other way is if the other parent may not have gotten state benefits, but if they go to them and request assistance from them, then the DOR in your state can, in many states, will just get involved and establish and enforce child support against you for them in that situation. So when the state's involved, they're just going to assume that that's your kid, right? So if you have any doubt at all that it could be your kid, if you have a question, we kind of broke up for that one weekend where she stayed at her girlfriend's house, and that was right around the time that she got pregnant. I mean, I don't personally believe that it hurts to request scientific paternity testing, make them prove that it's your kid. You just want to be careful how you request it, all right? Because if you say, hey, that's not my kid, she cheated on me, I want a DNA test. That's not the right way to ask, because if that turns out to be your kid and you're going after custody a few months later, well, I mean, now you've just kind of put this allegation out there in the court file that it's not your kid, that you don't even think it's your kid. And then you turn around and you say, oh no, I love this kid, I want to go for 50-50. That's not going to really, the judge is not really going to process that too well in your favor. So you want to say, hey, look, we were in a relationship. I do want to, if this is my child, I do want to pursue a relationship. However, there was a period of time where we split up around the conception, and in an abundance of caution, I think that it's in everyone's best interest that we, have a DNA test, just to be sure. Right now, that's probably the right way to ask, because no opposing attorney can spin that too bad against you later when you're going for 50-50. All right. The next way is, how do I avoid child support? This isn't really a way to avoid child support. This is more, kind of tactical. If you're in the litigation, if you got the pending court case, you just want to always make sure that you are doing discovery, right? You are making sure that whatever the other parent says they make on their financial affidavit, that they're not lying. Okay, because I'm going to tell you, I've been a family law attorney for, a little over a decade now, and every case involving child support, both parties have to fill out a financial affidavit. So that's a sworn, verified statement of how much they make. Okay, so I'm going to tell you, people lie on their financial affidavits, right? It's supposed to be sworn, right? It's supposed to be just like courtroom testimony. But people lie. They lie, and they do it in ways where, some of them are big lies, and some of them are just little white lies. But a lie is a lie. I mean, if you make $5,000 a month gross, and you say you make $4,500 a month, that's gonna move the needle on the child support calculations, right? Now, if the other parent fills out a financial affidavit to go after you for child support, and they say that, hey, look, I'm unemployed, my income is zero. And I pay my mom $1,000 a month to watch my kid while I go out and look for work, or while I go to school, or something like that, right? In a lot of those situations, I would say probably most of those situations that I've seen personally, at least. Okay, and I'm not trying to attack anybody, but it is what it is. They're not paying $1,000 a month to their mom or their sister or their aunt to watch the kid. They're usually paying nothing, right? They're usually making money. They're hustling on the side, or so they got money coming into their bank account. They got like PayPal, or they got Zelle or Cash App money coming in, hitting their account every month. They got a job. Maybe they got a W-2 job. They're just trying to tell you that they don't. Maybe they're working under the table somewhere, but they got money. They're making money, right? And but the problem is, when you're in one of these state DOR child support hearings, whether it's administrative or whether it's a circuit case in front of a child support hearing officer, they are not going to really hold the other parent's feet to the fire in terms of proving what they say they make. But you better believe that they're going to make you, prove, like, by writing it in blood, right? Every dime that you say you don't make. So just remember that. Their client, they're not going to make their client prove what they make or what their child care expenses are. But if their income is used at, it won't be used at zero. You'd usually be used at minimum wage. But if they use their income at minimum wage, assuming they're not making money, when they really are, if they give them credit for $1,000 a month, or even $500 a month, or even $200 a month of child care costs, daycare costs for the kid that they're not actually paying, that is going to mess your child support calculations up in all kinds of horrible ways, especially if you're not getting any credit for any court-ordered time sharing. So you really want to avoid that. You really want to avoid that, and the ways to avoid that is, if you can find a good lawyer. But when in dealing with child support with the state, most lawyers don't really get how to do child support against the state. It's a different kind of approach versus child support in a divorce or child support in a custody case. It's child support, right? In the end result is the same. Like it's usually dad paying money every month to mom, right, for the child. But the way that you establish it, the way that you attack it in the courts is totally different. And most lawyers don't get that. And so if you got money to hire a lawyer, if that's what you're going to do, make sure that they explain to you, like make them explain to you the differences between litigating child support between against the state and like an administrative or a case in front of a child support hearing officer against the state Department of Revenue versus child support in a divorce. All right. And if they can't very clearly articulate for you the differences between the litigation approaches and the procedures, then that I'm not trying to crap on other attorneys, but they're probably not the lawyer for you. Okay, maybe they're phenomenal in child support in a divorce. Maybe they're spectacular, but that doesn't mean that they're going to do the same level of work in a case involving the state DOR. And it's not necessarily their fault. It's just if you don't understand the difference in procedure and the process, you will usually get left behind and it won't be as good as it could be. All right, so that's one way. Hire a lawyer who knows what the hell they're doing. But that's not an option for a lot of people, right? That's not an option for most people walking around out here. Normal, hardworking people cannot afford a sky-high retainer for an attorney. It's just they can't. So the next thing you want to do is you want to make sure that you're doing discovery, okay? And so when I say discovery, I mean you're filing a discovery request. And I'm creating a course where I'm going to go into this in a lot more detail. And when it goes live, I'll link to it in the description of this video and all my other videos. But anyway, you're going to file a discovery demand where you are requesting, that the other parent at a minimum provide you their tax returns for the last 2 years, their pay stubs for all their income for like the last 6 months, their checking account statements for the last 6 months, savings account statements for the last 6 months, 6 or 12 months for those bank statements. Let's see, what else? I always get a copy of their residential lease, right? I want to see who all's living there, what's going on with that situation, how much they're paying in rent. Is it the same amount that they put on their financial affidavit? It's often not. If they're claiming, and this is a really important one, if they are claiming any daycare costs, all right, because that has a tremendous impact on child support calculations. If they're claiming a daycare cost, then they need to provide absolute proof of the money that they claim to be paying for daycare. And I always specify in my discovery requests, handwritten notes will not suffice here. In the absence of a handwritten note, or in the absence of a receipt from a licensed bonded provider, provide highlighted bank statements showing the money going from your account to the provider where it clearly identifies the purpose of the payment. I mean, you got to really get clear with this because people will get so shady. I don't know if some of the moms, again, nothing against moms, I don't know if some of the moms who are getting coached by some of the staff, with the state as you're going through here, but for some reason, a really uncomfortably high percentage of petitioners in these state child support cases understand that if they claim child care costs on their affidavit, that they're going to get a lot more child support. All right, I see it in a very uncomfortably high percentage of state Department of Revenue child support cases versus like divorce cases or regular custody cases, right, that don't involve the state. I don't really see that many moms. Yeah, sometimes it's dad, very rarely though. It's usually mom. But I don't see many moms in divorce and custody cases being dishonest about daycare costs. I just don't see it that much. But I see it constantly in these state cases. And I don't know, I mean, arguably people going through a divorce versus people going through the state, they have the same access to, research on Google and watch YouTube videos and talk to lawyers. But for some reason, the petitioners in these state cases, they have this information because they're doing it all the time. And that's why that's a standard ask in my discovery demands in these state child support cases, because it just, I mean, way more than 50% of the time, they will not respond to that request, right? They won't respond to that request, and they won't give me the proof of the child care costs that they're claiming. Because it's fraudulent. It's fraud. They're committing a fraud on the court. They lied on that sworn affidavit saying they pay $1,000 a month in daycare, and they know they don't, right? And that's why the discovery demand is so important. And this leads me to my next and final tip on avoiding this child support is when you file that discovery demand, and I have another video about this, about how the state dropped the child support case, so check that out too, because I go into more detail about this there. You file that discovery demand, you're requesting these financial documents, these pay stubs, these bank statements, these tax returns, and very importantly, there's proof of the daycare costs. If they don't respond, right, and this is more if you have a circuit court case, right? I don't know that this is going to work in an administrative case, but if you have an administrative case, right, if you're in one of the states that does the administrative child support process, when I complete the course, it's going to be done in the next couple of weeks. When I complete the course, there's going to be a really detailed section about how to take your administrative child support order and flip it to the circuit court so that you can do a lot of the things that I'm talking about here. When you did your discovery demand, you request all this stuff, they're going to usually have 30 days. That's usually the deadline in most states. They're going to have 30 days to turn all this stuff over. If you don't have it within the 30 days, you have to exercise your right to file these motions to enforce discovery deadlines. Where I'm at, it's called a motion to compel, right? But where you're at, it might be called something different. But the long and the short of it is it's going to be a motion that you file with the court to enforce that discovery deadline, okay? When they don't, you go to a hearing on that, okay? It's simple. And again, with the course, I'm not trying to hype up the course, but in the course I go into more detail about setting hearings and all that other stuff. You set your hearing on that, you get an order compelling or enforcing that discovery deadline against the other parent who didn't turn over their stuff on time. Okay. The court's usually going to give them like a handful of days, 10 days, 21 days, 30 days, whatever, to turn over their stuff. If they don't, then you file a motion for contempt. And in that motion for contempt, boom, one of the things you're asking for is that the court strike all their pleadings, dismiss their case. Right? Because most jurisdictions, that is a very legitimate request. And you can put in your motion, hey, look, by the petitioner's refusal to provide this discovery, it is essentially stripping me of my right to defend myself. It's stripping me of my right to formulate an adequate defense in court. It's stripping me of my right to properly and adequately cross-examine my accuser. Therefore, her noncompliance here has made it impossible for this case to move forward in a just manner. And therefore the court should, and I respectfully request that the court strike the petitioner's pleadings, dismiss her action, you can say with prejudice, but it'll always be without prejudice so that they can refile later. But I'm telling you, in every child support case, circuit court child support case with the state, where I've done this and we've gotten to the point of that contempt hearing, they've dismissed the case. It's so far, and I don't want to jinx myself, I want to knock on wood grain here, all right? So far, again, I hope I'm not like, giving myself bad luck now by saying this, but so far in state, circuit court, DOR cases, right, with child support hearing officers, this has worked 100% of the time, and they have dismissed the case. It works, and that's the other way to avoid it. Now, they will try to get their crap together. They'll try to get in contact with their client. They'll try to refile it at some later point in time. But, I mean, it usually takes them a long time because we're talking about a state bureaucracy, the Department of Revenue. They do, believe it or not, they do have some really good people there who care, that are working, but they are overworked. They are underfunded. They are underpaid. They are backlogged, right? So they are going to take a long time to get that refiled. And that's going to give you plenty of time to go and file a custody case to establish your parental rights and establish child support. In that case, where you have all your constitutional rights and you get credit for time sharing, court-ordered time sharing. All right, I've got other videos on strategy on establishing parental rights in child custody. All right, guys, so look, I'm over 21 minutes now. I appreciate you guys hanging through to the end. If this video added some value to you, please hit that thumbs up icon. That really helps me out in the YouTube algorithm. Also, if you're not a subscriber to this channel, I highly recommend that you do so. It doesn't cost a dime. It's free today only. No, I'm just kidding. It's free all the time. Subscribe to this channel. I'm putting out videos like this all the time. Very insightful, informational videos about the child support process. The good news is there's never a shortage of information, of topics for videos, because you're talking about child support, you're talking about family law. There is 10 million possible topics for videos, and every single one of them can help you out. So subscribe to the channel. Check out some of our other videos, guys. Class is dismissed. I appreciate y'all. I'll see you in the next one.